Thank you very much.
You're
Looking forward to it. Looking at it in detail. So thank you.
Okay.
All right.
Okay, we're good to go, Judge.
Thank you, Ms. Lewis. Good afternoon, ladies and gentlemen. My name is Judge Law, and this is going to be the Fulton County State Expedited Accusation Calendar. This is a calendar in which individuals have open, active misdemeanor cases against them. Upon being booked at the Fulton County Jail, the prosecutor, which is the Fulton County Solicitor General's office, has already accused these cases. Hence, they are now before the state court of Fulton County, and this would be the defendant's initial appearance before a judge. The issues we're going to address are namely to inform the defendant of what the charges are, who his or her attorney is going to be, what is going to be the bond, and when is the next court date. Please remember that these are active misdemeanor cases against you, so you have a right to remain silent. Anything you say during the course of this virtual recorded proceeding, your statements can and will be used against you. You have a right to an attorney if you cannot afford one. We have attorneys from either the public defense or the conflict defense who will be available to represent you. Courtroom 3, who do we have, please? I'm sorry.
Your Honor,
Yes, good afternoon. Who do we have?
we have first position is position number 2, Mr. Crowder.
All right. Michael Crowder, is that are you Mr. Michael T. Crowder?
Yes.
All right. Mr. Crowder, your case is been accused under number 22 CR 001954E.
Your Honor, I'm sorry, before you go forward with Mr. Crowder, Mrs. Hogue, I believe, represents Mr. Crowder.
Okay.
And she is having some technical difficulties logging in right now. She represents the first half of the calendar, and I represent the last half of the calendar of people.
All right. Miss Lewis, is Miss Elizabeth Hogue in the breakout room or in the waiting room?
No, she hasn't logged on yet. I've been watching.
Yeah,
All
she
right.
texted me and told me she had some technical difficulties, but she should be in soon. And I'm
All
not
right.
sure if it's her Wi-Fi or whatever, but
And Miss St. Flex, your cases start from which number to the end? From position 9? Which one?
I believe.
Mr. Hughley.
And
Mr. Hughley,
All right. And deputy, okay, let's hold off on bringing anyone forward. Mr. Fortas, who's your client? Scott Fortas?
Hey, Judge, how are you?
Fine, thank you.
It's good to see you. I have Keith Allison. They told me he was on today, and the family also told me they may have already posted his bond. So I don't know if he is on the calendar or not.
Oh,
I
he's
don't
not.
have him on the calendar. It appears that he was released. Is that correct, Ms. Lewis?
I was checking now. That's why I was just texting him in the chat. I don't have Allison. I'll double check, but I'm pretty sure that person was not on our pool sheet. So I will double check and see if that person may bond.
All right,
You just hold
Mr.
on tight, but I
Fortas.
think he probably has.
Yeah, if you want to hold, as soon as we get confirmation as to whether Keith Allison has been released or may be scheduled for Monday's first appearance. So hopefully that's not the latter, but I can't give you any more information. It's not on my calendar.
That's fine, Judge. I'll just stand by.
Okay, thank you. Courtroom 3,
Thank you as
who do we
well.
have, please? Courtroom 3.
I have Mr. Hughley.
Hughie, okay. All right. Mr.
That's number
Rodriguez. Mr. Rodriguez.
It's
Hughie.
right there.
I'm sorry. Okay, let's have one person speaking. Is that Mr. Rodriguez D. Hewley?
It's
Are
right
you
there.
Mr.
It's right there.
All right, it's Rodarius Hewley. All right, so I get the right person. Miss St. Flex, do you represent him?
I do, Your Honor. Maureen
Oh.
McLeod.
Miss McLeod, okay.
Yes, Your Honor.
And who represents Lorenzo Harris Brown? Would that be Miss Hogue or Miss St. Flex?
That would be Miss Hogue, Your Honor.
All right, so we'll hold off on Mr. Harris Brown. All right,
I
Mr.
start
Hewley?
on position 9, Your Honor.
Okay.
From 9 down, that's the rest of my people.
Okay. Mr. Hewley, you're accused of obstruction of an officer and possession of a pistol by a person under the age of 18. This is from an April 1st, 2022 incident. Unfortunately, this whole proceeding is not a joke. This is a very serious criminal matter against you. You're represented by Ms. McLeod, and you've been advised of your right to remain silent. Ms. Nakia, any priors on Mr. Hewley?
No, his first arrest.
All right, thank you. And Ms. Francis, good afternoon. What's your recommendation for Mr. Hewley?
Good afternoon, Judge. My recommendation, there's a bond already set, Judge, 3,000 on the obstruction and 5,000 on the possession charge for a total of 8,000, and no drugs, alcohol, or weapon while on bond. We request that the bond remain as set.
All right, thank you. Ms. McLeod?
Yes, Your Honor. My client is only 17 years old. He is an 11th grader right now in school. He tells me that he lives at home with his mom and his 5 other siblings. He has never been in any trouble before this, Your Honor. And he is presumed innocent. He currently is in school, and I think he needs to be out so he can get back to school. He doesn't have any money to post bond, he tells me, because he's not working, although he's trying to see if he can get employment at the airport.
We will need a cosigner. Who is his mother?
His mother, I have her number, Your Honor. I did try to call her, but I was not able to get her. But my plan was to continue to try to call her today. He also mentioned an aunt, and I've been trying to get her as well. But I did explain.
I need his mother's name.
Just a moment, Your Honor. I do have her name. Let me look in my notes.
All right.
Judge, if I may.
Yes, Ms. Francis?
Judge, we just want to put on record that this defendant has been seen at this location previously, and this location is a high crime area. The defendant does not live at this location. He gave a Campbellton address for his address. So the state does believe he's a danger to the community, and as such, we're making the recommendation.
Understood. Thank you.
Your Honor, being seen somewhere is not the same as committing a crime. People do have a right to be out in public. It's not like he was on private property or somewhere he was not supposed to be. It may be a high crime location. My client's only 17. He doesn't necessarily know that, and nobody has proved that he did anything. He just happened to be at this particular location.
Yes, and I will be granting a signature bond in part, but I need his mother's name.
I'm looking for it, Your Honor. I have it in my notes. Just
Mr. Hewley, what is your mother's correct legal name?
Santana Hewley.
Spell the first name.
Santana.
Santana?
Yes, ma'am.
You better be, okay, and the last name is what?
Miss Hewley.
McHughley?
Hewley.
It's the same as his last name, Your Honor.
All right.
Her name is the same as his last name.
I have Santana Hewley.
Yes, ma'am.
And what's her date of birth? What's her birthday?
All
right, let's leave it.
June 13th. June 13th.
What year?
1986.
June 13th, 1986. You're absolutely sure about that?
I'm positive, my lady.
Okay. All right, Miss is it Miss Nakia for pretrial?
Yes.
All right. Ms. Roberts, we are going to go ahead and set up a signature bond through pretrial for the obstruction charge, and that's going to be $3,500. And that's going to be a signature bond through pretrial services. I'll need his mother to co-sign, and that would be Santana Hewley. Apparently, she's born in June of 1986. So if we can ballpark that birth date, you don't have to be precise. I'm sure it can be verified by her driver's license. We will have that charge on a signature bond through pretrial. On the possession of a pistol by someone age 18 and under the age of 18, that's a $1,500 surety bond. Total bond is $5,000. All right, he'll be subject to a curfew. He will be in curfew from 6 p.m. to 6 a.m. He's only allowed to step out of the home for school, for church, for work, or to seek medical services and to attend court. He's to stay away from Lorenzo Harris Brown from this day forward. No illegal drugs, no alcohol, no weapons, no firearms. And he's to stay away from the incident location. Ms. Francis, what's that location, please?
It's 95 8th Street, Judge.
95 8th Street in Atlanta, Georgia. Thank you. And his next court date is going to be, would that be the 14th, Ms. Bridgewater?
It will, yes, ma'am.
If he makes bond, then we'll send notice to his address. If he doesn't make bond, his next court date is April 14th. And I think that concludes the case. Thank you, Ms. McLeod. Thank you, Ms. Francis.
Thank you, Your Honor.
You're welcome, Judge.
Ms. Roberts, there is no utility waiver. She will have to bring her driver's license or any government issued ID, plus a utility bill that shows her name and the address at which she lives.
McNair,
All right.
this is number 9.
All right, thank you. And Deputy, you can start bringing positions 1 onwards as well. Ms. Hogue is on our line. So we have Warren McNair, accused of criminal trespass, 22 CR 0019618 from April 1st, 2022. Mr. McNair has been advised of his right to remain silent, and his attorney is Ms. St. Flex. Any priors, Ms. Roberts?
Yes, 52 cycles. Last arrest was March 13th of this year for criminal trespass out of Fulton County. That was time served. He has a criminal trespass conviction in 2015, a driving without a valid license conviction in 2019, disorderly conduct conviction in 2014. He appears to have an open case out of Bibb County for DUI and acquiring a license plate for purpose of concealing identification of motor vehicle. That arrest date was
That's good. That's
Okay.
good. Thank you. Ms. Francis?
Yes, Judge, the state is recommending a 3,000 surety bond and a stay away from 3360 Peachtree Road, which is the MARTA station, and no drugs, alcohol, or weapons while on bond. I'm not aware if MARTA has issued a stay away, Judge, so hence the reason for the stay away.
Okay. Ms. St. Flex?
Yes, Your Honor. Mr. McNair has informed me that he does have a 205 Sycamore Street, Decatur, Georgia address that he can go to upon being released from the jail. Currently, his bond is $5,000. I think the prosecution asked for $3,000. We'll be asking for a signature bond, Your Honor. He's not able to afford a $3,000 good bond. He hasn't been working. We would be asking if the court is not inclined to give a signature bond to reduce his bond to $1,000 good bond. He does have family and ties to the community. He has 3 brothers and a sister that lives in Georgia, from my understanding, and a daughter who's 43.
All right. Bond is set at $1,500. It's a surety bond. Next court date is April 14th, and he's to stay away from all MARTA property, all of them.
No. All right, thank you. It's time for him to turn it all over to me.
All right, we're going back to case number 2, Your Honor.
Thank you. Deputy, do you have a Keith Allison in your courtroom?
Allison?
Yeah, Allison.
I just already checked the
Allison?
case and made bond,
All right.
and I let Mr. Fortress know, so he already left it.
All right, good. Thank you. All right. So position number 1 then?
No, position number 2, Your Honor.
Oh, 2, excuse me. Michael Crowder. Michael Crowder. I beg your pardon. All right, Mr. Crowder, as I was saying, your case is 22 CR 001954E, in which you were accused of misdemeanor obstruction of an officer on April 1st. You've been advised of your right to remain silent, and your attorney is Miss Elizabeth Hogue. Miss Roberts, any priors, please?
18 cycles. Last arrest was in 2016 for burglary, aggravated assault, and cruelty in Brookhaven. There's no disposition listed, so I'm not sure what happened with that case. A FTA from 2015, a willful obstruction of a law enforcement officer from 2015 conviction, a possession of a vehicle with altered ID mark conviction from 2014, 2010 disorderly conduct, criminal trespass, misdemeanor marijuana possession.
Does he have any holds right now?
Double check. I'm not showing any holds at the moment.
All right, thank you. Ms. Roberts, excuse me, Ms. Francis, what's your recommendation?
Yes, Judge, the state is recommending a 3,000 surety bond and no drugs, alcohol, or weapons while on bond. We'd also like to point out or reiterate what pretrial just stated, that he does have a previous obstruction conviction in his record.
Ms. Hogue?
Yes, Your Honor. Mr. Crowder is 30 years old, Your Honor. He has his GED and he's also done, work as an electrician's apprentice. He's currently employed, Your Honor, and he's been gainfully employed during this tough time and getting what things are opening up. He's been gainfully employed for over 10 months at Liberty Tire Recycling. He has been in Atlanta for 20 years. He has significant family ties here. He also has 3 children, 10, 8, and 7 that live with him. He currently supports, as well as a 4th one that he helps to support that lives with his mother. And so, as I said to her, he has significant ties here. The criminal history I'm hearing about, the earliest I'm hearing is 2016, which puts that 6 years ago, and everything is further back than that. So, Your Honor, while we recognize he does have a history and he is not recommended for a pretrial release, we would ask for a bond of $1,500 at most.
Bond set at $1,000. It's a good bond. His next court date is April 14th. Thank you.
Thank you, Your Honor.
That's it.
Thank you, Your Honor.
Position number 5, Mr. Greer. Greer. Guys, stop talking, please. We're trying to do this.
We have case 22 CR 001957F, State versus Tyler Mage Gear, accused of reckless conduct from April 1st, 2022. Mr. Gear, you've been advised of your right to remain silent, and your attorney is Ms. Elizabeth Hogue. Ms. Roberts, any priors on Mr. Gear?
No, first arrest.
All right, thank you. And Ms. Francis, do you have a recommendation?
Yes, Judge, 5,000 surety bond and no drugs, alcohol, or weapons, specifically guns, while on bond.
All right, and Ms. Hogue.
Yes, Your Honor. First off, Mr. Greer has absolutely no history. This situation was 2 friends who were, in a car. They were delivering for Uber Eats. Okay, he and Mr. Jamison, Your Honor. The weapon in here, the reckless conduct was he had an empty soft pellet gun that could not be fired, had no ammo, and didn't have an air cartridge in it. And he and his friend were joking around. He pointed at his friend and he pointed at himself. Someone saw this and thought it was dangerous and reported it. Mr. Jamison explained that this was just harmless. There's not even harm from an empty, it was a soft pellet gun. It wasn't even a bullet gun. It had no pellets in it. And it had no air cartridge. It couldn't even shoot. To say that he has to have a $5,000 surety bond when there was not even a potential that this could even be considered necessarily reckless conduct, Your Honor. He has absolutely no history. He has been granted a pretrial release, and we see absolutely no reason why he should not. He has got his GED. He should be starting college soon. He's been here all of his life. His father, his brother, everybody lives here. He has significant ties. And so we do believe that a signature bond is warranted in this case.
I'm sorry, Judge, if I may.
Yes.
Judge, 5 officers responded to the scene with guns drawn. This was a very dangerous situation. It may not have been for the participants because they knew what they were doing and what they had, but everybody else who were looking on would assume that he had a gun.
Yeah.
Not just pointed at the other party, but at himself as well.
I totally understand, and I hope Mr. Gear and his family eventually realized how dangerous that situation was, whether it was done in fun and play or whatever. But the bond is going to be set at $3,500. It's a signature bond through the jail. No weapons, no firearms. And that means, sir, that from this moment onwards, until this case is resolved, you are not to handle any kind of weapons or firearms. It may have been a harmless weapon at the time that it was around, but it's really in the eye of the beholder. It's not what you were thinking, it's what others were thinking. And this led to a very dangerous situation. So this is an open active case against you, and you're required to stay away from weapons and firearms. You cannot have any on your person. You can't have any on your home, in any vehicle you occupy, or anywhere near you. And as I said, this is an active case. You need to come back to court. I just want to confirm that your mailing address is Delk Road?
Correct.
All right. You will get notice of when to come back to court. If you don't come back to court when summoned, or if the notice goes to a different address because we have an incorrect address, then a bench warrant will be issued for your arrest. Do you understand?
I understand.
All right. See you next time. Thank you.
Position number 6, Ms. Hamilton.
We have Kayla Hamilton accused of violation of a protective order and driving while license suspended or revoked. And is she a co-defendant, or does she just have another open case?
I believe she may have an open case, Your Honor.
All right. Ms. Hamilton has been advised of her right to remain silent, and her attorney is Ms. Hogue. Ms. Roberts, anything to add?
On 2 cycles, with the last arrest being in 2016 for driving without a valid license and aggravated assault. That was a first offender. That first offender was sealed in July of 2021. And she does appear to have an open simple battery case, 22 CR 001407A. And nothing further.
Thank you. And Ms. Francis?
Yes, Judge, the state recommends that the 1,000 surety bond that's already set on the driving while license suspended remain as is, and that a surety bond of 4,000 is set on the violation of the protective order for a total of 5,000 surety. Obviously, Judge, this defendant has no regard for the court. Right after court was when she made contact with this victim, and the court order said that she shouldn't have had contact. So she has no regard for the court. So the state believes that the recommendation is appropriate under these circumstances.
All right. Ms. Hope?
Yes, Your Honor. Ms. Hamilton is 28, Your Honor. As you can see, she has the one first offender which she completed successfully, and that is 6 years old when she was much younger at 22. And the current outstanding one was a family situation, which I believe has both she and her sister having a fight, which on my understanding is going to be most likely dismissed at this time. As far as her disregard, Your Honor, this was she was on a Zoom call for the court hearing for this TPO. After that Zoom call, she contacted her son's father. Miss Harvey, the person part of the protective order, also has a child with her son's father. She contacted him to say she was coming over there to pick up some child support money. Now, Miss Harvey doesn't live there, okay? And he was well aware that she was coming over. When she went over there to get that at her son's father's address, not Miss Harvey happened to be there. When she saw Miss Harvey, she stayed in the car and did not get out, and did not become aggressive. She was not aware Miss Harvey was going to be there. They apparently now, they do share a similar father for both their sons. So she was not disregarding the order, Your Honor. It was a simple mistake, which I've explained to her now. Because of this, she'll have to work out something where, because they seem to share the same father for their sons, that she's got to make sure that this would not happen again. But it was not just a disregard. I do believe, Your Honor, that in the case of the suspended license, $1,000, it was suspended. She is trying to get it resolved. But I do believe a signature bond in the other case, in the other charge, is warranted, as this was not a defying the order, Your Honor. It was simply a mistake.
Okay. On the driving a license suspended, I'm going to keep it at $1,000 good bond. On the violation of the protective order, that's going to be $1,000 good bond. Total bond is $2,000. It's a surety bond. Next court date is April 14. There's already a TPO with regards to Octavia Harvey. In a condition to this particular, in addition to that order, the condition to this surety bond is no further contact with Octavia Harvey. I'm going to let you speak and put your hand down, which means that if you happen to be in location and you see or you know of Miss Harvey being present, you are to turn around and leave. You cannot sit in the car and wait for the dad or wait for somebody else. If she is physically in that location, you have to make sure that you are 200 yards away from that person. And that's what a TPO means. All right. Driving while license suspended or revoked, this remains a good bond because this is not your first offense in the last few years. All right. Now, Ms. Hamilton, if you want to say anything, please remember that this is a Zoom recording. Your statements can and will be used against you if you want to discuss the alleged facts of this case, and it will not only possibly incriminate you or make it difficult for your attorney to represent you.
Ms. Hamilton, I would recommend as your attorney to not speak at this time. If you have some questions or issues, I will certainly be glad to take them up afterwards.
You're not on mute. Talk if you want to say.
Oh, no, it's just about, when I was there, she.
Ms. Hamilton, please do not speak.
Okay.
Please do not speak.
All right, that concludes this case. Thank you.
Position number 7, Harris Brown. I'm going to ask, but not right now.
Lorenzo Antoine Harris Brown is case 22 CR 001-959Y, accused of loitering and prowling, willful obstruction of an officer, and possession of a pistol or revolver by an individual under the age of 18. He is the co-defendant with regards to Rodarius Hewley, and he's represented by Miss Elizabeth Hogue. And I understand Miss Roberts, he has no priors either, right? No adult arrest?
He does have,
no,
he got one prior adult arrest.
Oh, when was that?
February 23rd of this year. And it is for purchase, possession, manufacture, distribution, or sale of marijuana, and possession of a pistol or revolver by the person under 18 years of age, and theft by taking. That case number is 22 CP 206934 and 22 CP 206935. And nothing further.
All right. Well, okay. My bad. Miss Francis?
Yes, Judge. The state is recommending a 1,000 surety bond for the loiter prowl, 3,000 surety bond for the obstruction charge, and a 5,000 surety bond for the possession of firearm, for a total of 9,000 surety. A stay away from 95 8th Street, and no drugs, alcohol, or weapons while on bond. Judge, this defendant does have 3 cycles, but the most recent, which is February 23rd, it's the exact charge that he's here on less than 2 months later. So it's evident that there's a high risk for reoffending for this defendant, and he's obviously not adhering to court orders. So the state strongly believes that this recommendation is warranted.
Ms. Hogue?
Yes, Your Honor. Mr. Harris Brown is 17, Your Honor, and we do recognize that he has the prior charges at this point. I don't have to point out the court that he's innocent until proven guilty, as we know, but we do still understand all the issues regarding this. I had a strong conversation with him regarding the fact that he had a weapon. And having read this, I'm not even sure the loitering will apply, Your Honor. I understand the obstruction and the possession, but I don't believe in reading the fact that loitering would even apply at this point in time. So that is one we would ask for a signature bond on. We do recognize that he is, like I said, he does recognize the situation he is, and he's very, very had a good, strong talking to by me. Just to let you know that he is still in high school. He is attending Atlanta Virtual Academy. He's born and raised here. He has 3 brothers, 3 sisters, a mother, father, aunt. He has plenty of family, Your Honor, so he has complete ties here. He was going to get work at the airport through his aunt so that he would also be gainfully employed as well, Your Honor. So while we recognize that, he does have those pending charges, and that what he did was not what he should have been doing or what he should have been carrying, but also note this happened about 2 o'clock in the afternoon, Your Honor. And based on what I read, the police simply pulled him over after following him around while he was simply on a scooter scooting around, Your Honor. This is not late at night. There's not anything like that. So just 2 o'clock in the afternoon. So what we would ask for is on the loitering, a signature bond, and for $1,000 on the obstruction and $2,000 on the revolver.
All right, thank you. On the loitering and prowling, that's going to be $1,000 signature bond through the jail. On the willful obstruction of an officer, that's going to be $1,000 surety bond. On the possession of a pistol or revolver by a person 18 under the age of 18 is going to be a $2,000 cash bond only.
Your Honor, I would ask maybe that you rethink that.
I trust me, I've read it. I thought about it. I came on at 2 o'clock. I've heard both sides. And I've changed my mind from 5,000 to 2,000 cash.
Okay, thank you, Your Honor.
This is going to be a 2-3-4 split bond. Conditions are no weapons, no firearms, and that means you cannot have any weapons or firearms on your person, in your home, anywhere near you, or in any vehicle that you occupy. You are to have no further contact with Rodarius Hewley after today. You're to stay away from the incident location, and that was 95 8th Street in Atlanta, Georgia. And that's it. We'll see you on April 14th. Thank you.
Judge, no curfew for him, Judge?
Oh, I'm so sorry. Yes, he has a curfew. It's going to be a 24-hour curfew. He's only allowed to step out of the home in order to attend school, to attend work, if he has one, to attend court and to seek medical services. If he needs to attend church, he can pray at home.
Judge, I think I'm not sure if I heard Ms. Hogue say that they were both looking for a job at the same place.
I don't know that. I just know his aunt works at the airport and he was going to be looking for a job at the airport with his aunt. He has
My
relatives
client
there.
did say he was looking for a job at the airport as well, Your Honor.
All right. So if they don't have jobs, then they cannot step out of the home.
And I'd like to report back, Your Honor, that I did have an opportunity to speak with my client's mom.
Oh, Miss Hewley?
I did, Your Honor, and
Okay.
I have told her of the court's directives concerning his bond and the curfew and so on.
All right. Excellent. Thank you.
May I be excused, Your Honor? He
Yes,
was
Ms.
my only
McLeod.
client.
All right. You enjoy your weekend. Thank you.
Thank you.
Position number
Same to you,
11, Your Honor,
Judge.
Mr. Powell.
Yes.
Yes. Thank you, Ms. McLeod. Deputy, I'm sorry. What was that position number?
11, Powell.
Thank you. We have Antavious Mikhail Powell, case number 22 CR 001963D, accused of 2 counts of reckless conduct on April 1st, 2022. Mr. Powell, you've been advised of your right to remain silent, and your attorney is Ms. St. Plex, I beg your pardon. Ms. Roberts?
Your Honor, before it starts, I have 1 count on the booking sheet, but then I think there's 2 counts on the calendar.
Yes.
I think I have 1 warrant, so I just want to verify that it's 1 count of reckless conduct and not 2.
According to the accusation on Odyssey, they have accused him of 2 separate counts, but you are correct, there was 1 warrant. Okay. Ms. Roberts, please continue with this priors.
First arrest.
All right, thank you. Ms. Francis? Oh, excuse me,
Your
Ms.
Honor.
Arnold. Yes, all right, good afternoon.
Hi, good afternoon. Yes, Your Honor, and I requested a breakout for this position. And just so you're aware, I requested breakouts for positions 10, 11, and 14.
Deputy is, okay, is Nancy or Corey in your courtroom, or is she at Union City?
I was gonna make the announcements in the beginning, Your Honor, but you said he was moving, so.
Oh, I'm sorry, go ahead. What's the announcements?
Number 10 would be a medical reset.
Number 10 will be a medical reset. Okay, thank you.
I'll give you all of them while we
Yeah,
here.
sure, go ahead, go ahead.
Position number 1 is gonna be reset.
Okay. Siobhan Allen is a medical reset.
Position 3 bonded out.
All right. Roger Doyne is released.
Position 4 is a reset.
Okay. Is it also a medical reset?
Yes, ma'am. Yes,
Okay.
ma'am.
And do you know if, what was the other one? 10, 11, and 14. Is 14 available?
Ms. Stevens.
Amari Stevens?
Yes, he is.
Okay, good. Mr. Powell, I will address your case very shortly. Can I address anyone else in the back who's not had a turn?
I have one more announcement for you, ma'am.
All right, go ahead.
Position number 13 has bonded out.
All right, Holly Smith has been released.
Position 15 is here in court. 15, we can do him.
Okay, yes, please. Then I'll have to go into a breakout for the 2 remaining cases. Jonathan Manzor.
And Mr. Seats is here at position number 12.
Okay. All right, Jonathan Manzor has been accused of battery causing substantial physical harm in case 22 CR 0019668 from May 14th, 2021. Mr. Manzor, you've been advised of your right to remain silent, and your attorney is going to be Miss Clarissa St. Flex. Ms. Roberts, any priors, please?
He has 8 cycles. Last arrest was from 2014 for theft by shoplifting. That case was dismissed. Last conviction was in 2011 for theft by shoplifting.
Okay, thank you. Ms. Francis, sorry, Ms. Arnold?
Yes, Your Honor. So the state is requesting a $7,500 surety bond for the battery substantial physical harm. No further contact with Nicole Ortiz. Nicole spelled Nicol, Ortiz, Ortiz. A 1-day anger awareness, no drugs, alcohol, or weapons. We are not asking for a stay away since it appears the victim lives at a different address. Your Honor, based on the facts of this case where the defendant hit Ms. Ortiz with his vehicle, which was a Rubicon Jeep, in her right knee, leaving her with bruising, we are requesting that stated bond, Your Honor.
And this is a misdemeanor battery?
Your Honor, yeah, so we are looking into transferring it, but we were not able to do so before court today, which is why the bond is requested is so high. But yes, we are looking at as prosecuting this as an aggravated assault.
All right. I see Miss Nicole Ortiz on the Zoom conference. Miss Ortiz, my name is Judge Lal. Are you the Miss Ortiz involved in this case?
Yes, ma'am.
All right. You have a right to not say anything if you choose to do so. You also have a right to add anything to the proceedings if you'd like to. If you like,
Your Honor, I'm sorry, Your Honor. Go ahead.
Go ahead. Go ahead.
I just wanted to say I spoke with Ms. Ortiz, so if I can speak a little bit about what I expect her testimony to be, if she has one, if she has something additional she wants to add, if the court would allow me to speak first.
All right. I don't see a problem with that. Go ahead, Ms. St. Flex.
Yes, Your Honor. If the court looks at the citation, this is an incident that allegedly occurred May 14th, 2021. So almost a year ago, last year, Mr. Humanzar denies, and I apologize if I'm saying your name wrong, sir, denies the allegations. I spoke with Ms. Ortiz, and she does not have any problem with contact. They've been together since this date. Ms. Ortiz does have a little bit of an issue with emotional control. She did contact the police that day, Your Honor, but I think the prosecution hasn't partly been able to move forward with a felony case because the only thing that's in this case right now that we have is a citation that says she was hit. There's no bruises. There's no picture of anything. Ms. Ortiz didn't go to the hospital. She didn't seek any medical treatment, go to the ambulance. There's literally just a citation that says he hit her with a vehicle. Post-incident, Your Honor, Ms. Ortiz did inform me that she got some psychological therapy and that she's doing better since this incident. And so we have reasons to believe that the allegations as listed are not completely true. And Ms. Ortiz does not feel in fear of Mr. Humanzar at all. And as she stated, she is fine with him having contact with her. And if the court is so inclined to add no further violent contact, we don't have an issue with that. He is eligible for pretrial per the pretrial report. So we will be asking that he's released on pretrial. There hasn't been any incidents since this date to take place. And I think the last conviction that we've heard of is a 2014 theft. So I haven't heard of anything that's violent that says that he's going to go out and commit any violent incidents. And I think if the court wants to hear Ms. Ortiz confirm that, she can. Also, Your Honor, as to
Okay,
those.
yep, I'm going to pause right now. I'm going to listen to Ms. Ortiz now.
Okay.
Ms. Ortiz, do you want to add anything else to what Ms. St. Flex has already said?
Yeah, in the moment that I did the report, you know, we got into a fight.
I need to place you under oath. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
It will be the truth.
Okay. Now, do not talk about the incident, but more importantly, talk about how do you feel about contact with him or him having contact with you, or do y'all live together?
We don't live together, but we have a relationship. I was going to pick him up at the airport, and you know, this threw me off because I didn't know that he had a warrant because of that report that day. After the incident, we talked and he explained that he wasn't trying to intend, you know, to harm me, and he has never tried to like hit me or do something like against me.
All right, thank you.
Your Honor, if I may, just to
I was going to ask you for a rebuttal and then I'm about to rule. Yes, Ms. Arnold?
Okay, yes, Your Honor. Just to clarify, the warrant itself, what Ms. St. Flex is referring to, it did not indicate the bruising. However, the police report does state that she did have bruising on her knee. And I would just like to point out that Ms. Ortiz did not, in her testimony here, she did not say that the defendant did not hit her with the car. She just said it was not he did not intend to hurt her. So, Your Honor, we are still requesting the stated bond with the conditions. Thank you.
Okay, thank you. What is unequivocally true is that something happened, such an incident did occur, apparently according to the warrant. And just based on my prior experiences in doing these criminal cases, this is never, ever, ever a misdemeanor case. Someone being struck with a vehicle is always a felony case if there's a modicum of intent. So Mr. Umanzor, I'm not sure why your case is merely a misdemeanor case, but that's really up to the prosecutors. It's not up to me. What I have to decide is, while this case is active and pending against you, whether you should be released on bond. I'm going to issue a $10,000 signature bond through pretrial services. You are to have no further violent contact with Nicole Ortiz. That means no physical or verbal altercations with her that may involve the police. No drugs, no alcohol, no weapons, no firearms. And you are to maintain a current mailing address and contact information with the court at all times. You are not to travel outside the state of Georgia without a court order permission. Do you understand?
Do we know for how long?
Until your case goes to trial. And no further violence, and that's it. And your next court date will be sent to you at your current. You'll be reporting to pretrial every month, and you'll be subject to drug and alcohol screens. And as I've said, anyone being struck with a vehicle should have been a felony case, but that's really up to the prosecutor. So I would caution you to please try to avoid any infractions with the law, because you don't want to give them a reason to do so. Understood? I guess you do. Thank you. That concludes this case.
Position number 12, Your Honor. Mr. Seats.
Ms. Ortiz, I think you're free to leave if you want to.
Thank you.
So, all right. Gary Lee Seats is accused of battery, domestic violence, and criminal trespass and damage to property on April 1st, 2022 in case 22 CR 001964E. Mr. Seats, you've been advised of your right to remain silent, and your attorney is Ms. St. Flex. Ms. Roberts, any priors, please?
No priors, first arrest.
All right. And Ms. Arnold?
Yes, Your Honor. So the state is requesting a $3,500 surety for count 1 for the battery family violence, and for count 2 for the criminal trespass and damage to property, a $1,500 surety for a total of a $5,000 surety bond. We're asking for a stay away from 1238 Epworth Street, Southwest in Atlanta. Epworth spelled Epworth. No further contact with Melissa Shelley. Melissa spelled Melessia. Shelley spelled Shelley. ADET evaluation, a one-day anger awareness course, and no drugs, alcohol, or weapons. Your Honor, we do believe that the defendant will reoffend. Ms. Shelley advised our victim advocate that the defendant gets out of control and becomes verbally abusive when he drinks, but took it a step further this time by actually physically abusing Ms. Shelley and pushing her to the ground, leaving scratches on her right elbow and her lower back, Your Honor. So for these reasons, we are requesting the stated bond with the conditions. Thank you.
All right, thank you. Ms. Simplex, I could let Ms. Seats speak. Did you want to go first?
Yes, Your Honor. I spoke with Ms. Seats this morning, and she said that she was not in fear and that Mr. Seats can return home. They've been together for 21 years, but married for 11 years. As you heard, this is his first arrest. He does have significant ties to the community. He was born and raised in Atlanta, and we would be requesting that he's not required to do the ADET, Your Honor. I think if the prosecution comes up with a program that is free for evaluations, then possibly indigent clients should be required to do so. But as long as they have these programs that cost money, $150 to $200, and then more than that, depending on the classes, someone could be in violation of their bond simply because they cannot afford to do the programs that's been offered. So we would just request that's left for later as something as a conviction or if he pleads to the charge. I think he is currently working, Your Honor, based on our conversation. So we would just ask that he's allowed to leave jail on his eligible pretrial bond release because he is eligible for pretrial, and that the court orders no further violent contact so he can return home.
All right, thank you. Ms. Melissa Seats, my name is Judge Lal. If you want to address the court, you are free to do so. Otherwise, you also have the right to remain quiet about this proceedings. What would you like to do?
I would just like to say that we have 5
you under oath, Ms. Seats?
Yes, ma'am.
If you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge. I'm sorry, was that a yes?
I said yes, ma'am.
Okay, what would you like to tell me?
Like I said, we've been together 21 years. We have 5 boys together. So to have a no contact order, I think that's not wise. Our youngest son is 6. The oldest is 17. He's getting ready for National Guard. So their dad has played a major role in their life. And it was just a disagreement that happened that day. We do not fear him at all. So I just want him to be able to be around his children and to be around us and just to get some kind of help with the drinking, and that's it.
What is the name of his stepson?
Malik Shelley.
Does Malik Shelley live at the same location?
Yes, he does.
Anything else?
No, that's all.
Thank you.
Your Honor, I will ask if the court is inclined to order some sort of classes. We would be requesting maybe 1 or 2 AA classes a week because that is a free program. So we just wanted to insert that for the court.
All right, thank you. All right, on the battery domestic violence, that's going to be $5,000. On the criminal damage to property, that's going to be $2,500. Total bond is set at $7,500. It's a signature bond through pretrial services. While you are released on a signature bond, Mr. Seats, you will complete an alcohol and drug evaluation and subject yourself to any treatment that is required, and that has to be done by a qualified provider. And this must be done within 30 days of being released. And if the treatment requires you to, you need to listen, if the treatment requires you to attend AA classes, then you will attend no less than 1 class, at least 1 class a week. While you are out on bond, you will also undertake a one-day anger awareness program that is offered through pretrial services. You are to have no further contact with Melissa Seats, no further contact with Malik Shelley. You are to stay away from the 1238 Epworth Street, Southwest Atlanta. You may return to that location one time only with a police officer to retrieve your personal belongings. Within 30 days of being released, you will update the court with your new mailing address. No illegal drugs, no alcohol shall be consumed. You'll be subject to random screens by pretrial services. You'll be reporting to pretrial once a month. If you get arrested again, if you fail to comply with the conditions, or if you return to the location or have contact with either Ms. Seats or Mr. Shelley, you could be arrested and brought back to jail again with no bond. You may have contact with the other children with whom you share with Ms. Seats, but that would have to be done outside of Epworth, and I will allow for a third-party transfer of the other children. Thank you. Okay, Deputy, do we have anyone else to address in court other than
Ms. Stevens?
who else is left for a breakout, Ms. Arnold?
Miss Okori, Mr. Powell, and Miss Stevens.
All right, Ms. Okori is reset to Monday. This is a medical reset.
Okay, I'm sorry, I missed that, Your Honor. Yes.
Yeah, Mr. Antavious Powell, is he the one seated in front of us? Antavious Powell, who was the other one?
Amari Stevens, position 14.
All right, Amari Stevens.
So I have Mr. Powell and Ms. Stevens here in court, and the other young lady is medical reset.
Okay.
You're doing a breakout session for those two, right?
All right, Deputy, if you could hold for a few moments, I'm going to go into a breakout with Ms. Arnold and Ms. St. Flex, and who else?
Mr. Condritzer.
Mr. Condritzer, okay. Ms. Lewis?
Your Honor, I would ask that my client is present, and I would object to him not being present unless it's his first arrest, so unless the prosecution is gonna give me a MH reason of why we are doing a breakout room and my client is present, then I'm gonna object to a breakout.
All right. Objection noted on the record. Your client's gonna remain in the courtroom while we go in a breakout. Thank you. Ms. Lewis, it will be Ms. Arnold, Mr. Condritzer, myself, and Ms. St. Flex, please.
Ms. Seat, you're free to go. Your case is over with. You're free to go.
I'm sorry, I was too busy still working. I'm still at
I
work.
see you working, honey. I see you working. But you're
Yes,
good
ma'am.
to
Thank
go.
you.
You're welcome.
Bye-bye.
Thank you. All right, we will first address position number 14, position 11, Antavious Powell, please, if you please come forward.
I got it.
All right, Antavious Mikhail Powell is case number 22 CR 001963D, accused of 2 counts of reckless conduct. Ms. St. Flex is correct. There is a 1 warrant in which they have alleged 2 separate victims, and the alleged incidents from April 1st, 2022. And Mr. Powell, you've been advised of your right to remain silent, and your attorney is Ms. St. Flex. Ms. Roberts, any priors, please?
First arrest, Judge.
All right, thank you. Ms. Arnold, what's the recommendation?
Yes, Your Honor, the state is requesting, I'm sorry, I'm on the wrong case. Give me 1 second. Okay, yes, Your Honor, the state is requesting a $5,000 surety bond for count 1 for the reckless conduct and a $5,000 surety bond for count 2 for the reckless conduct for a total of a $10,000 surety. A stay away from 2115 Meter Avenue, Southeast in Atlanta. No further contact with Eric Powell or Sabre Powell. Sabre spelled S-A-B-R-A. MHET, no drugs, alcohol, weapons, or firearms. Based on the facts of this case, Your Honor, where the defendant fired 1 round into the kitchen floor with the black handgun, while Mr. Powell, his brother, and Mrs. Powell, his mother, were standing next to him. We are requesting the stated bond with the conditions.
All right, thank you. Ms. St. Flex?
You're muted.
Apologies, Your Honor.
No problem.
First, Your Honor, I think the case law has been pretty clear. This was a same transaction and occurrence. So the fact that the prosecution has separated it into separate cases, I think it's going to be a motion in the future. And so I think the $5,000 on each charge is not warranted. Further, Your Honor, as you heard, he does not have any priors. He's eligible for a pretrial release. We are asking the court to allow him for the pretrial release. I did speak with him about the address situation and if he was no longer allowed to return to the address. First, he does deny the allegations as listed, Your Honor, and the only thing I believe I seen was a citation that stated that happened, but nothing further to verify the incidents that he's being accused of. He does have a godmother who lives at a different address that he can go live with. And he was born and raised in Atlanta, so he has significant ties to the community. His daughter, who's 7 years old, who he currently works to support. So we would just ask that he's allowed to be released on a pretrial bond, Your Honor.
All right. On the first count of reckless conduct, that's going to be a $2,000 surety bond. The second count of reckless conduct, that's going to be a $2,000 signature bond through the jail. The surety bond applies to the charge for which we have an underlying warrant. Full bond is $4,000, and that's going to be a split bond. No further contact with Eric Powell and Sabre Powell to stay away from the Meadow Avenue location. I believe that's where the incident occurred.
Yes, Your Honor.
All right. And if he has personal belongings at that location, he may return one time only with a police officer to retrieve his personal belongings. He must update the court with his new mailing address within 30 days of being released on bond. Furthermore, he's not to consume any illegal drugs, no alcoholic beverages, and not possess any firearms or weapons. He cannot have any weapons or firearms on his person, near him, in any home he occupies, or in any vehicle that he occupies. All right, next court date is April 14th. This is position 14. Is this Amari Stevens?
Yes, ma'am, it is.
Thank you. This is case 22 CR 001965J. Amari Stevens is accused of battery, domestic violence from April 1st, 2022. Ms. Stevens, you've been advised of your right to remain silent, and your attorney is Ms. Clarissa St. Flex. Any priors, Ms. Roberts?
Yes, 3 cycles. Last arrest was in 2019 for possession with intent to distribute. In Maryland, that was a conviction in 2019, and nothing further.
All right, thank you. Ms. Arnold, yes.
Yes, Your Honor. So the state is requesting a $3,500 surety for the battery family violence, a stay away from 6851 Roswell Road in Sandy Springs, no further contact with Sierra Bay, spelled B-E-Y, 1-day anger awareness, an MHET evaluation, and no drugs, alcohol, or weapons. Your Honor, based on the facts of this case where the defendant slapped Ms. Bay in the face and then proceeded to bite her on her right breast, we are requesting the stated bond with the conditions. Thank you.
All right, thank you. And Ms. St. Flex, shall I address you first or Ms. Bay?
I did speak with Ms. Bay earlier today. She stated that they do have a lease together. She does plan to move out of the property in 30 days. They just signed that lease and both of them are on that lease. So she's requesting that the court gives 30 days where she's not allowed, my client is not allowed to return to the property. But after that, she can return to the property and reconvene the lease that they're both right now liable for. So we would just ask the court to do that. She says that she's okay with no further violent contact. After that, I did explain to her that she had the option of no further contact, but it seemed to be that she would prefer no further violent contact, Your Honor. And as to her ties to the community, Your Honor, she has been living here for a little while now, I think over a year. They moved here together. They've been together for, I believe, almost 2 or 3 years. She is a veteran, Your Honor. She was medically retired. And we are just asking the court to allow her to be released on the pretrial bond that she is eligible for. I don't believe we heard anything violent in her history, nor did we hear any FTAs. And originally, this was charged as a simple battery family violence. So we would just ask that she's allowed to be released on pretrial.
Okay, thank you. Ms. Bay, my name is Judge Law. If you want to address the court, you are free to do so. Otherwise, you're also free to not say anything. What would you like to do?
Yes, ma'am. At this time, I won't say anything. She pretty much summed everything up for me.
All right, good. Thank you. Bond is going to be set at $5,000. It's going to be a signature bond through pretrial services. Ms. Stevens is going to report to pretrial once a month. She is going to attend and complete a, excuse me, she's going to attend and complete a 1-day anger awareness program. She will also attend and complete 1 MHET. And pretrial will explain that to her. Ms. Roberts? MHET, okay? She would have to go to a qualified provider. And if the evaluator seeks that she needs to have continued treatment, then she will comply with the treatment plan.
Okay.
She can sign up for the bond today. She won't have to pay anything, but she cannot live at this location, which is 6851 Roswell Road in Sandy Springs. She cannot return to that location as long as the victim, Sierra Bay, lives there. She's to have no further contact with Sierra Bay. She's to stay 200 yards away from Miss Bay and not communicate with her in any way, form, or manner, which includes in person, through any kind of phone or computer device, or through social media or third party. Returning back to the, I guess the rental location may also be subject to whether the landlord permits Ms. Stevens to return to the location. So given this particular matter, Ms. Stevens has 30 days to update the court with her new mailing address. No illegal drugs, no alcohol, and no weapons and no firearms. Her next court date will be sent to her at her new mailing address. Now, Ms. Bay, I do understand, Sierra Bay, I do understand that both of you on the lease, so you may want to consult with the landlord with regards to your rent obligations, okay? They may have a different perspective. You may want to let them know that you have a domestic violence case in which you are the alleged victim, and then talk to them about your rent obligations.
Yes, ma'am. I do have a question though. Is there any way that we can do something to where she is not allowed on the premises, but we are able to still have contact regarding the bills and everything else that's needed to part ways?
Right now, it's no further contact. There's to be absolutely no communication. If she initiates contact and Ms. Stevens responds to it, she'll be in violation of a bond order. If both of you mutually agree to meet and have contact, that's entirely up to the both of you. But if law enforcement get involved, they could have her arrested again and charged with a felony aggravated stalking, which carries no bond.
Yes, ma'am. Thank you.
All right. I believe that was the last case, Deputy.
That is correct, Your Honor.
All right, then this court is concluded. I'm just going to go over the cases with counsel.
Thank you. Am I?
Yes, sir. You're free to go. Thank you. Have a good
Thank you.
day. Enjoy your weekend. Okay. Position 1 is Siobhan Allen is a medical reset to Monday, which is April 4. Michael Crowder was a $1,000 good bond, reset date April 14. Position 3, Doyle was released. Position 4, Finley is a medical reset to April 4. Unless, of course, the defense counsel wants to waive their appearance, then hopefully we'll be able to address them on April 4th. Position 5 is a 3,500 signature bond to the jail. Reset notice will be sent to the Mr. Gear. Position 6, Hamilton's a $2,000 surety bond. Reset date April 14. Position 7 is a $4,000 split bond. Reset date April 14. Position 8 is a $5,000 split bond. Reset date April 14. Position 9 is a $1,500 good bond. Reset date April 14. Position 10, Okori is a medical reset to April 4th. Position 11 is a $4,000 split bond, reset date April 14th. Position 12 is a 7,500 signature bond through pretrial. Reset date will be sent to the new address provided to the court. Position 13, Smith was released. 14 is a $5,000 signature bond through pretrial. Reset date will be sent to the address provided by Mr. Stevens, Ms. Stevens. And position 15 is a $10,000 signature bond through pretrial. Reset date will be sent to the address provided by Mr. Umanzor. I guess the same, wherever he lives. All right, Ms. Ho, Ms. St. Flex, Ms. Arnold, Ms. Francis, any questions? We good?
No, Judge, we're good. Thank you. Enjoy your weekend.
You too. Thank you, Ms. Ho. Thank you, Ms.
Thank
St.
you,
Flex,
Donna.
Ms. Arnold.
Thank you.
All right, Ms. Holly, I'm not letting you go